let's go ahead and get started with this panel.
Yeah.
My name is Elizabeth Reese, and I'm an assistant professor here at Stanford, so welcome to the sunshine. So we're just going to go ahead and jump right in, as we have been doing, because we all seem to know each other in this community. So this panel is on public fiduciaries and the history of Article 2. So John, if you want to go ahead and start.
Great. Thank you very much, Liz. Let me start by thanking the organizers for inviting me. This has been a wonderful conference, and I want to thank Michael and Jed and Morgan for all the work that you've done to put this event together. Like many of the speakers, I'm an alumni of this law school, and it's a special thrill to be back here at Stanford and with all of you. So my paper is called The Path of the Prerogatives, and I want to try to summarize it for you and get to the key points. I begin by describing three issues or conceptual problems that I face when I think about the history of Article 2, and that make me think that, to some extent, the entire field may be somewhat misconceived. And I call those three problems: first, the path of the prerogatives; second, the distinction between executive powers and government powers; and third, the status of the United States as a legal corporation. And I'll try to explain what each of these 3 points means. My focus on the three issues stems in part from my interest in James Wilson, but not entirely from that source. I've been working on a book manuscript on Wilson. Its tentative title is The Man Who Wrote We the People, James Wilson and the Formation of the United States. And Wilson, of course, is a critically important founder when it comes to the creation of the presidency. He played a pivotal role in the creation of the presidency. So it was Wilson, for example, who first proposed that the executive power of the United States be vested in a single person, who first called for the president to be popularly elected, and therefore independent from both Congress and the states, and who drafted the first versions of the vesting clauses, including the Article 2 vesting clause and the take care clause, in his capacity as a member of the Committee of Detail. And furthermore, Wilson's statement that unity in the executive, instead of being the fetus of monarchy, would be the best safeguard against tyranny, is the statement from the convention that is most frequently cited as the source of the name of the unitary executive theory. That is where that term, I think, most prominently comes from, that statement from Wilson's. And he's certainly a founder who is frequently invoked by unitary executive theorists as an inspiration and someone whose ideas are informing that theoretical position. On the other hand, there are some other facts about Wilson that I think have to be brought into the discussion about presidential powers. So, to begin with, Wilson conceived of the implied national powers of the United States quite differently, I think, than many contemporary unitary executive theorists, in a way that I'll try to explain. Wilson played a critical role in what I'm calling the path of the prerogatives. Between 1774 and 1777 in particular, so this path by which the royal prerogatives outlined in Blackstone enter into American law, Wilson's 1774 essay played a critical role in that process, in a way I'll try to explain. And then, of course, Wilson was the author of the Necessary and Proper Clause in the Committee of Detail. And on my view, any coherent understanding of the scope and nature of executive power under our Constitution has to come to grips with the Necessary and Proper Clause. We have to have a theory both of Article 2 and, at a minimum, the Necessary and Proper Clause, which bears on presidential powers as well as every government power, and vests Congress with the express authority to carry into execution all of the powers vested by the Constitution in the government of the United States or in any department or officer thereof. And that formulation that Wilson used is critical because on its face, it requires us to distinguish the powers vested by the Constitution in the government of the United States as a whole from the powers vested by the Constitution in any department or officer of the United States, including Congress and the President. And that is a critical distinction, I think, for understanding how Wilson understood presidential powers, but also I think how most of the founders did. It helps explain a lot of the controversies in the early period, fighting over just what the implications of that formulation were. And finally, Wilson was arguably the most seasoned corporate lawyer among the founders. What do I mean by that? Well, not in our sense of a corporate lawyer, but in a recognizably analogous sense. Wilson was a lawyer for many banks and land companies and corporations, early American corporations, and he did this work of drafting corporate charters and putting them into execution before he served on the Committee of Detail, before he drafted the Constitution, or the first draft of the Constitution for that committee. For example, the United Illinois and Wabash Land Companies. Wilson drafted the charter of those companies. It's actually a corporate merger between two independent companies, the Illinois Company and the Wabash Company, and he unified them into one constitutional scheme with a document that was called a Constitution that vested powers in a president who happened to be Wilson. Wilson was the first president of that United Land Company. And there are traces of language in that corporate charter that one finds in the way Wilson drafts the Constitution for the Committee of Detail. And likewise for his draft of the charter of the Bank of North America in 1781, Dickinson College in 1783. He helps Benjamin Rush with that project. So insofar as we really want to understand how founders like Wilson understood the idea of the United States as a legal corporation, we ought to investigate how they understood the formation and the investment of powers in other corporate bodies, just as the ones that I mentioned. So this is some background about Wilson. Let me sort of pivot now and try to join issue with some of the things we've been talking about at this conference. So in my paper, I try to make some specific claims that bear on some of the contemporary debates around presidential powers, and a good place to start might be with Michael McConnell's terrific book that's been discussed thus far about the formation of Article 2. I think that Michael is quite right to focus on what he calls the audacious innovations of the Committee of Detail in creating the presidency. But I worry that there may be a tendency for some readers to come away with a misleading impression of what actually happened. The impression, I think, that might be created is one of the Committee of Detail, or maybe just the two principal actors in the story that Michael tells, and I think he's right to identify these as the two principal actors, namely Wilson and John Rutledge. The images of the two of them, or maybe the whole committee, sitting around, maybe at Wilson's home in Philadelphia in late July or early August of 1787. They have a copy of Blackstone's commentaries on the table in front of them. And what do? They rifle through Chapter 7 of Book 1, and they allocate the royal prerogatives to Congress and the President. That's a captivating image, but I think it's misleading for at least two basic reasons. First, most of the prerogatives outlined by Blackstone and allocated by the committee were already vested in the United States by the Articles of Confederation. I provide a list of roughly 18 of those powers in the paper. We could argue maybe there's, that's a give or take, but it's certainly true that most of the powers that the committee allocates are already vested in the United States by the Articles. The second factor here came up in our conversation yesterday. It has to do with the fact that Resolutions 6 and 7 of the Virginia Plan had already called for vesting the existing legislative rights and executive rights, respectively, that were vested in the United States in Congress assembled by the Articles. The Virginia Plan and those resolutions called for vesting those in a new legislative and executive body, so what we now understand to be Congress and the President. But as I think came out in our conversation yesterday, it's not clear, at least it's not clear to me, what the plan, or what the framers of the plan meant by executive rights and legislative rights. There are a lot of ways one could interpret what those two phrases meant in Resolution 6 and 7, because there's a lot of ways to think about the Articles of Confederation and about what that body was, and whether it was, for example, a legislative body with executive powers, an executive power with a body with legislative powers, whether these were in fact government powers as opposed to legislative or executive. So there's a lot, I think, that has to be unpacked there. So at least speaking for myself, I have a hard time understanding how to interpret what the committee did with respect to Resolutions 6 and 7 without answers to those questions. And I think they're not easy questions. And let me try now to elaborate some more complications here, how we understand this story, at least how I think of it. And that's by talking about the path of the prerogatives. So I'll just try to simplify this story a little bit. I guess the question here that arises, I just stated it, but let me reformulate it again. By 1787, were the powers vested in the United States by the Articles legislative powers, executive powers, government powers, or something else? I think that the best interpretation, at least for someone like Wilson, who plays this pivotal role in the Committee of Detail, is that he probably conceived of these powers as government powers, primarily. That is, as powers, as national powers vested or belonging to the government of the United States in the first instance, rather than primarily legislative or executive at that point in time. And this flows from the history that I recount in the paper, the path of the prerogatives. The Committee of Detail was by no means writing on a blank slate. So what was the path of the prerogatives? Well, I don't have a PowerPoint slide, but I wish I did, especially after Aaron's very helpful slides. But let me try to conjure up an image for you. Maybe you can think along with me what such a slide would look like. At the top, we might have the label, the path of the prerogatives. We might have an image like the image on the cover of Leviathan, or maybe with Blackstone's image in the place of the sovereign. And then we'd have 4 columns with a picture of 4 individuals: Wilson, Franklin, Dickinson, and Jefferson. And the path of the prerogatives is the story of how, first by Wilson and then by the others, prerogative powers were used in the imperial crisis to flesh out the American theory of the British Empire, and then, of course, to vest the powers in the United States as a result of the Declaration and the Articles. So for Wilson, the powers were war, peace, alliances, commerce, appointments, and the royal negative. Franklin, in his first draft of the Articles of Confederation, essentially began with that list and added 6 or 7 more: ambassadors, currency, post office, armed forces, disputes between colonies, new colonies, and Indian affairs. Dickinson then in 1776 began with Franklin's list and added about 6 or 7 more. And each time Franklin and Dickinson, they're drawing from Blackstone. They're just unpacking things that Blackstone already described. So Dickinson adds letters of marque and reprisal, rules on captures, commissions, the creation of courts, weights and measures, coining money, fixing the value of coin, and so forth. That is how the prerogative powers got into the Articles of Confederation, which was the primary source from which the Committee of Detail drew, not Blackstone necessarily. Of course, Blackstone is in the mix, but I think we really have to think first and foremost about the Articles, as I've tried to say. And then Jefferson. What does Jefferson do in the Declaration? He reaches back to Wilson and says that these free and independent states have the power to, what are the powers? War, peace, alliances, commerce, and all other things that independent states may of right do. So that's Jefferson's sweeping clause in the Declaration, and I think he's by reference incorporating all of these other powers that have now been in play in the Continental Congress. In the paper, I point out that there's a very good case to be made that Jefferson had Wilson's 1774 essay in front of him when he composed the Declaration, because the similarity between what Jefferson says in that final passage and what Wilson says in his essay is extremely close. There's a long debate among historians about the extent to which Jefferson was drawing on Wilson's essay in composing the famous self-evident truths passage of the Declaration, but I think even the stronger evidence comes in this final passage of the Declaration. Well, what's the key point? What's the key takeaway from all this? It seems to me that the prerogative powers in this path, this story, went from being vested in the king to vested in the United States. That's in fact the language that's used in both the Articles and the Declaration. There's a question, of course, how do we understand the reference to free and independent states? Is it 13 independent states or one undivided nation? In the paper I say I think it's not an either-or question, but a both-and. I think for framers like Wilson, they thought both things. These were free and independent states, all 13, but there also was a single undivided nation that was created. And importantly, at the very point in time that this is all happening, the Articles is depriving the states of all of these royal prerogatives. They're clearly national powers vested in the United States, not powers that are recognized as belonging to the individual states. That's what the Articles does. And I think it's really important just to focus on the role of Blackstone in all of this. All of these individuals knew their Blackstone. He's absolutely critical. This is the overhang. The last part of the paper, and I'll try to summarize this more quickly, is devoted to filling in some of the details on this nationalist understanding of the Declaration and the Constitution that Wilson certainly believed in, but I think many of the founders believed in. Two key sources of jurisprudential ideas are the law of nations and the law of corporations. On the law of nations, or the nationalist side of things, it's not just Wilson, it's Franklin and Dickinson, it's Rufus King and the things he says at the Constitutional Convention. It's Justice William Patterson in the case of Penhallow versus Doan's administrators. It's what Justice Sutherland, future Justice Sutherland, wrote in the early 20th century when he wrote a book about national power and world affairs. There are a lot of important figures in our history, both founders and later jurists, who are embracing this conception of implied national power. And I think it's a very plausible conception. And on the side of the law of corporations, I cite to Pennsylvania Chief Justice Thomas McKeon's opinion in the Swears case, where he says quite clearly, the United States was a corporation, became a corporation right from the get-go, and many founders, many important founders said similar things. Hamilton, Ames, Sherman, Cushing and Iredell in the Chisholm against Georgia case, and Chief Justice Marshall in two important cases decided on circuit. He says it absolutely crystal clear. The United States is a corporation. The Constitution is its charter. It's vested with all of the typical corporate powers, like those unenumerated powers, such as the power to own property, to sue and be sued, to operate under a common seal, to enact bylaws. There are a host of unenumerated powers that are vested by the Constitution in the government of the United States that are not vested directly in Congress, the President, or other departments or officers of the United States. Wilson certainly understood that. Marshall certainly understood that. And I believe one can't understand the Constitution in its original formation without understanding that. Now, the slogan that Madison used in the bank argument, this is a government of limited and enumerated powers, is pretty hard to square with that reality. And I think it's so much the worse for the slogan, not so much the worse for the reality, because there are, in fact, powers vested by the Constitution in the government of the United States that are unenumerated. And we'll never quite understand what the necessary and proper clause is doing and why it was worded in the way it is without coming to grips with that. So to close, let me just give you how I think the reference in the necessary and proper clause to other powers vested by the Constitution and the government of the United States ought to be interpreted, or at least how Wilson, the author of the clause, interpreted it. I think he assumed, and many of the founders did assume, that that phrase referred at a minimum to all of the powers which any nation would ordinarily be entitled to under the law of nations, such as powers over foreign affairs, Indian affairs, immigration, other incidents of national sovereignty. And in addition, all of the powers that Blackstone, Wilson, and other writers had explained were tacitly possessed by any legal corporation without having to be enumerated. So the power to own property, to make contracts, to sue and be sued, to operate under a common seal, to enact bylaws, and other implied corporate powers like the power of removal. So my view is that the most plausible understanding for why the removal power was not enumerated in the Constitution is that it's an implied corporate power that any corporation gets for free. Of course a corporation has the power to remove its officers, and of course the United States has the power to remove its officers. There is then a further question about who gets to do that, who gets to carry that into execution. But there's no question that the United States has that power, and it's vested by the Constitution. And then finally, I would include, and I think Wilson understood himself as including in this clause of the Necessary and Proper Clause, the power to legislate on all issues that affect the general interests or harmony of the United States or that lay beyond the competence of the individual states. In other words, this is how the Committee of Detail and Wilson incorporated the so-called Bedford Resolution into the enumeration of powers. It was voted up in the convention by an 8-2 vote eventually, only South Carolina and Georgia dissenting, I think for reasons having to do with slavery. And there's always been a question, what happened to the Bedford Resolution in the Committee of Detail? I think the strongest case is to be made on behalf of the Necessary and Proper Clause, and it's incorporated by reference into those other powers vested in the government. And finally, I would include under this category the power to fulfill the purposes for which the government of the United States was formed, including but not limited to those ends enumerated in the preamble of the Constitution and the General Welfare Clause. And this is how best to explain why so many members of the First Congress in debates over the Bank of the United States, assumption, the oath, removal, were appealing to a general residual implied power in the government of the United States to fulfill its purposes, to carry into execution the purposes enumerated in the preamble. That's a lot of implied power. I recognize that it puts me in an outlier position among participants in the debates that we're having, but it is a view that is one I've devoted many years of study to, and I do think it's a plausible one and at least worth taking seriously. So thank you very much, and I look forward to the conversation.
Great, thanks. Thanks everybody for including me. The paper I put together for this conference, I think in a least charitable fashion might be seen as somewhat intramural or sort of axe grinding or somewhat navel gazing about work I've been trying to get clear about for so the better part of a decade, with a lot of different kinds of co-authors, sometimes political theorists, sometimes philosophers, and then more recently constitutional historians, and I think that's why I've ended up here. But the more, hopefully the more charitable way to look at my contribution here is really a kind of a meta-analytic or methodological intervention, trying to take stock of a wide range of work that's not just being done by me and co-authors, but a wide range of constitutional historians that are trying to figure out ways that fiduciary conceptions make their way into the original meaning of the Constitution. And lots of non-originalists are doing this too, and their arguments are largely in political theoretic terms about ways conflicts of interest within constitutional governance create needs for different kinds of institutions or different kinds of legal development through common law. But the originalist version is a claim about history and a claim about that can be verified by looking at traditional originalist sources. And what I sought to do in, I guess, Babettian style in the paper is to try to outline core modalities that I'm seeing out there, some of which I've contributed to, some of which I'm ambivalent about, some of which overlap. And so I think it's a bit of a stylized typology that I'm offering you, but I think it captures something to help you see how these different arguments are proceeding. So I outlined three different modalities of originalist fiduciary constitutionalism. The first you might call document type or instrument type originalism. And this is to try to say, in some respects, a little bit like you just heard from Mikhail, the Constitution is a document that is familiar to lawyers of the time, like we just heard, a corporate charter. Nadelson has a view that it's mostly an agency instrument, and so Lawson and Seidman have a whole book that the Constitution is really a power of attorney, or is like a power of attorney, and we can learn a tremendous amount about the meaning of the document because we know what type of document it is. And then Jed and I sort of opined in a book review about the Lawson-Seidman book. Well, maybe we should think of it better as a trust instrument, and maybe different kinds of legal outcomes would follow. For example, about the pardon power, or about the way to think about non-delegation. So Lawson and Seidman are very sure that because it's a mere power of attorney that the Constitution is, the non-delegation doctrine naturally follows therefrom. If you take the position that it's a trust instrument, you might have a very different story about what the status of delegation law was in that regard. So that's one type of fiduciary constitutional argument that you see out there that's of an originalist form. The second, probably much more conventional, I'm calling clause-bound. I don't think the people who are clause-bound originalists are not interested in reading their political theory or their Locke, but the kind of argument that these originalists take tends to focus much more on the clauses, whether it's the sweeping clause or whether it's the general welfare clause. And it takes the format of these clauses appear in fiduciary instruments, or these clauses are familiar to lawyers who know a lot about fiduciary law. And so, this is not something Mikhail does, but it is central to Nadelson's approach to all of this. It incorporates extant fiduciary law at the time, right? So the fixity that originalism produces for us happens through incorporation, through the use of these clauses. So, I mean, to the extent that corpus linguistics is going to continue to make its name for itself in originalist thinking, it's not now taking the format of what I'm calling fiduciary constitutionalism, but it is also clause-bound in the sense that it takes phrases and tries to figure out, where else do these phrases appear, such that we might be able to learn something about the original meaning. And then the last modality is one I'm calling Conceptual Foundations originalism, and I'm sure almost everybody would say, oh, of course I'm a Conceptual Foundations originalist. I mean, we've all read our Bernie Bailyn. We all want to know what the anxieties and preoccupations and fears and political theory they were reading. So in what sense, then, is the Conceptual Foundations originalist actually distinctive? The clause-bound originalists aren't going to say we don't read our Locke, and of course Nadelson and Lawson and Seidman are all populated by some basic political theory. But I do think that even spotlighting the distinctions of the different modalities help us understand the kinds of claims that can be asserted on behalf of meaning. So those who believe you can incorporate by reference with the clauses, Nadelson to wit, has a long list of very clear legal outcomes that follow, because once you have an extant body of private law that you think is being incorporated, you know exactly what kinds of remedies are permissible. You know exactly whom to sue. You know exactly whether it's courts or impeachment that is going to solve the problem of breaches of the obligations that you find. The more analogical story that happens with these, let's call them the document type originalists. So if all you think is that there's a power, the Constitution is like a power of attorney, the Constitution is like a corporate charter, you might be somewhat more modest because you know what you're doing is largely trading in analogy. Okay, and then for the Conceptual Foundations originalists, which I'm considering myself one today, I probably was less careful about this earlier when I was first starting because I wasn't as self-conscious in methodology. I think there's an extreme modesty. I think that what the Conceptual Foundations originalists feel like they can say is that they can find standards of conduct, not standards of review, not clarity about the mechanisms. And the reason that I'm so focused on that particular difference that the modalities make is because in a broadside attack on fiduciary constitutionalism as a project, and this is a paper by Bray and Miller that came out in the Virginia Law Review, I mean, it just lumps all of this together, all of these different modalities into one. And I think that without being able to see the distinctions among them, you're just not as clear on what kinds of critiques stand and which succeed and which fail. So to the extent that you think learning some analogies about, the framers knew a lot about corporate charters. They might have had, and you'll hear it probably from Sugarman in a moment, they had some ideas about removal that probably were implied as default rules in any corporate charter whatsoever. I mean, that's really important to know, but does it produce exact conclusions about exactly what the removal authority was supposed to look like and in whom it was invested? Probably not. Like, we just don't get the fine-grained clarity. I mean, one of the things that struck me in the last panel, I mean, Michael Paulson, if we had more time for a conversation, just so much confidence about the meaning in the paper. And I think the Conceptual Foundations originalists they want to give you clues and help you understand that the take care clause and the oath to take care that the laws are faithfully executed, these are part of a long-standing practice over hundreds of years. And that doesn't mean anything specific was incorporated. It doesn't mean we know exactly what kind of remediation is possible, but it is hugely relevant for understanding the actual meaning of the document. So even if we concede with Paulson from the last panel that the right thing to be looking at is the original public meaning, right? It doesn't mean that we need to look at the word level. It doesn't mean that we need to understand only what type of document it was, but the conceptual foundations are going to give us lots of clues about how to make sense of what the meaning is. And we have to have, I think, requisite modesty about the plausibility of being able to reason from those conceptual foundations into workable rules of constitutional law. The last thing I guess I wanted to walk through with you was just on this last point, sort of how do you make political theory into law? One of the things that you hear from those who criticize this mode of originalism is to say, look, that's really interesting that sometimes people use the word fiduciary or drew on the language of trust, but it really was just moral guidance. It really is just political wisdom. It has nothing to do with law and certainly not legal meaning. Right? And I think that that's wrong, and I try to show that in this paper at the end by highlighting different ways in which the use of this language was in part metaphoric, and I don't think anyone would deny that, but the project of constitutionalism itself was very much tied up with figuring out how to make political theory law. It is a meaning-making enterprise, and the inheritance of the ideas that the king was a fiduciary who would be punishable by law for breaches of trust. What kind of law? In what court? Through what method of argumentation? None of that is disposed of. But it's very hard to say this is a mere moral suasion. From time immemorial, even prior to the founding of the Constitution, impeachment trials routinely use the language of fiduciary trust as they try to figure out who should no longer hold their office. Now, does that mean impeachment is the only mechanism for remediation of breaches of trust? I'm doubtful, right? It is structural features of the Constitution, choices that are made about who gets to remove or for what reason are implicated by the conception of office qua trust. And so I think it's a big mistake to try to reduce all of this fiduciary theorizing into mere moral suasion. Exactly what the legal implications are, exactly how it's supposed to ramify in our ongoing project of figuring out what the original meaning of the Constitution was, I don't think we're there yet. But there's a lot of actual law that I think can be squeezed out of it. Thanks.
Great. Terrific. Well, first let me say you've heard plenty from me yesterday, so I'm going to stick to 10 minutes. But let my 10 minutes start after I do some housekeeping or publishing. Let me just make sure everyone has met who's presenting and has written knows Yvonne. And so please, as we are moving forward, Yvonne is is the Americanist at the American Journal of Legal History, which will be publishing for those who have been involved with the peer review. But it'd be great if people check in with both Yvonne and me and Michael about what the plans are next. It helps us give preview of what lengths might be for our articles as more latitude. But let me shift, I think, to this question of the prerogativism that we're talking about, fiduciary constitutionalism, and civic republicanism, because I think that these are all examples of the cross-ideological, cross-partisan ways of identifying the rule of law that bring together, as you know, I think the panel yesterday, the first panel on prerogativism, I think there is a remarkable degree of consensus about the significance of prerogatives that brings together from the range of the American political spectrum. Kroski, which I would not have known. I didn't know about Kroski's work until I read Michael McConnell's book. It brings together McConnell, Eric Nelson, Julian, Elon Werman, all in I think, terrific, generative, and balanced work that moves beyond, I think, what had been the partisan assumptions. You know, Michael's book, A President Who Would Not Be King, is deeply Republican, and it embraces defeasibility against what I think has been some formalist party lines. And there is also tremendous engagement that I think also brings together people on the left to identify the importance of the rule of law. Republicanism is part of that too. That I think prerogativism, republicanism, and fiduciary constitutionalism bring together a lot of different ideas across the spectrum. So an example of that, as we've talked about, the three of us were at Georgetown at Randy Barnett's conference in the spring of 2018, engaging with his book that is largely promoting the non-delegation doctrine, Gary Lawson and Guy Seidman, as we've talked about the great power of attorney. And it was a terrific conference that I think was generative and brought together lots of people with lots of different views. And frankly, it helped shift me towards, I don't know, a little bit more openness to the non-delegation doctrine, and I'm publishing something that embraces a certain aspect of the non-delegation doctrine. So a little bit more of shouting out about originalism. I think the projects that we're also, I think, engaging with are deeply engaged with Michael Rappaport and McGinnis's original methods originalism. That the idea of identifying fiduciary, well, as Ethan is identifying the process of fiduciary constitutionalism as original methods. And that's part of what the project, and I've also benefited tremendously from John McKeil's work, as I indicate, about this basis of corporations and charters. So I think one more thing I wanted to say before we get there is that there are also other scholars that we couldn't include in this conference, but I think it is important to identify Jane Manners and Lev Menand, Christine Keksel-Chabot, and Noah Rosenbaum, who are all doing outstanding work. And it also picks up, and I think this is part of the law of offices I want to pick up from yesterday, because I think that work is a better explanation for Marbury than I think the existing explanations, and it ties in directly to the law of offices as property. That is a better explanation for Marbury. So what we heard, we've heard, yesterday's engagement, we heard a lot of different explanations. Justices of the peace, when Marbury is decided and Marshall says that the justices of the peace like Marbury are not removable, there have been a lot of different explanations. None of them fit the actual explanation that Marshall gives, and I also made a mistake in my own book where I talked about the 1801 to 1803 midnight judges fight. I made the assumption that they were just conflating the judicial aspect of justice of the peace in what seemed to be either a mistake or a part of Chief Justice Marshall's jujitsu move of trying to get to protecting Federalists and establishing judicial review. Aditya gave an explanation yesterday where he asked us to look at the background from a lower court opinion identifying justices of the peace as Article III judges. I just don't think that fits. I mean, a 5-year term would really not be what one would identify as an Article III judge. That isn't really the argument that Charles Lee makes. He identifies them as having a judicial background, but he doesn't assert that Article III. And that's also not what Chief Justice Marshall says. So he says, in the end, he says, this officer is not removable by the executive. And the bottom line is, he says, Mr. Marbury then, since his commission was signed by the president and sealed by the Secretary of State, was appointed and as the law creating the office gave the officer a right to hold for 5 years, independent of the executive. The appointment was not revocable, but vested in the officer legal rights which are protected by the laws of his country. I didn't understand that passage until I read the work of Jane Manners and Lev Menand, which explain and connects with Blackstone a deeper history of the law of offices as property. And so what they show is that there were, and this connects with Blackstone. Blackstone identifies offices as a classical hereditament, inheritable property. And so Blackstone has, among many passages, he identifies, one is that for a man may have an estate in them, in offices, either to him and his heirs, or for life, or for a term of years, or during pleasure only. Those are 4 separate categories: inheritable, offices for life, offices for a term of years, or removable or held at pleasure. And so what's going on there with Blackstone? It's actually a deep history in Western Europe. In this paper, one of the things I talk about is that one of the overlooked causes of the French Revolution, not overlooked by French historians, but overlooked by I think the professors who work on administrative law, is that in the medieval to the early modern period, it was very important that there was a transition, and this also ties directly into Nick Perillo's work on offices, not by salary, but by fee, that offices were an investment as property. That to move from a feudal system and give up your land as agriculture to then taking an office, that was an investment in your family as a new way of making money by fees. And in order to make that investment, that office as property was only worthwhile for that investment, just like it's only worthwhile for someone who's practicing law to leave law practice and take a position in academia if it's protected with tenure of office. So the same investment had to be protected by law. So it turns out that Montesquieu identifies this as a major passage about the importance of offices as property. They read Montesquieu, they read Blackstone. This is why the phrase executive power does not include removal, because this was the background. It was obvious to them that in order for these offices as property to be an investment worthwhile, it had to be protected, and in the English system, it was protected as freehold property. So given that absence, so then is the Constitution silent about removal? And I think that's not, I don't think originalism has to leave us with silence. Either we have clarity from texts or clauses, or there's another method, and that method is called original methods originalism, piggybacking on or relying on McGinnis and Rappaport. And so in brief, the bottom line, building on John McKeil's outstanding work, Ethan and I started a series of conversations where we started looking at the law of corporations, and at the same time that Lev Menand and Jane Manners were doing their work. And at the risk of being overly, so the irony here is that I'm criticizing a certain kind of formalism, but I'll use the formalism of a syllogism based on these original methods. And so starting with, I think, John McKeil's work, the first step of the syllogism is, A, the framers understood the Constitution to be a form of charter, a form of corporate charter. I think there's a lot of synthesis on this panel about that first move. The second move is that it turns out that as we dug into Blackstone, Blackstone cites a series of cases that are about corporate removal as a default power. So the default rule for corporate charters, if silent on removal, is that it implicitly empowers amoval, which is the term for corporate removal, but it is, as a series of cases that we've identified, listed in Blackstone, Baggs' case from 1615. I might want to call this project the 1615 Project. Okay. Thanks, Jack.
Not a good idea.
You got it. At least Jack's got my back. There's Baggs' case, Lord Bruce's case, and Rex versus Richardson. Blackstone talks about these cases as creating a default rule of corporate removal, but there's more. The default rule is it has to be by good cause. It is not at will. Why? Because of the fiduciary instrument of corporations and property and private rights. Your private right could be removed, you could be removed from a kind of private right, but only with good cause. That's the background that we can fill in here. So that's the second step of it. So C is, the Constitution is silent on removal. Impeachment doesn't count as a removal, not as a functional kind of removal. And so D, ergo, the Constitution's default rule as a move of original methods originalism for removal was that there has to be a requirement of good cause to allow, there has to be a removal or removal, but it's limited by good cause. And who's the parallel office holder that would be match the corporate charter? It would be an executive, whatever that executive was. In the corporate context, it would be an executive council or a board of trustees. But in the Article 2 context, it's a unitary president with that power. And so the upshot here is, and that Congress can then elaborate on what that default rule is, but good faith, faithful execution is right there in the Constitution. Good cause is a cousin of good faith, and then Congress can elaborate on what it means to exercise and be required to show, in the reasons going back to Aaron and Chris's paper on the Congress's anti-removal power. It's that anti-removal power is to specify the process. And so ultimately where this leads us is actually, it explains Taft and Myers. Myers makes sense, not because of anything, Taft did not make these moves, but the Senate would not exercise this power based upon this kind of original methods originalism. So I'll leave it there, but I think the goal here is, I think, to be a project of engagement with a variety of sources, and to take originalism seriously, and to make sense of the Constitution as opposed to simply saying, if it's silent, anything goes. I think the rule of law requires us to look at original methods to fill out those gaps in the Constitution.
Great. Thank you all for those great presentations. So I am going to just keep my remarks really brief. I have, sort of two responsive points that are more general, and then two that come sort of more specifically from the fields that I write in that are not otherwise really on point today, which is Indian law. So the ones that are more general. So one of the things about the concept of fiduciary constitutionalism here is that it really is, I think at its heart, a theory of relationship and duty. And one of the sort of perpetually frustrating or distracting things for me about this is that there's already another theory of relationship and duty that's very important to the Constitution and very clearly in there, and that's democracy. And I just can't help but feel like I'm banging my head against a wall a little bit, like worrying about how there is this possibility that by focusing too much, or really focusing at all on these types of concepts, we are potentially distracting from very important discussions of how democracy, like accountability, like power, access within the scope of the Constitution and how it's structured, and the electorate and how they're able to hold different people democratically accountable, is then getting put into this other space where instead we're sort of having this other conversation about what other work this type of fiduciary responsibility is doing, and that can end up just being a sort of convenient distraction we're putting too much leverage on. And so I wonder, especially as scholars who work in this area and think about these questions, how you guys are navigating, like knowing that it can play this role in these debates that can even, enable concerning things instead of other important conversations about democracy. I think particularly also, John, when you mentioned that Wilson authored the We the People, I also was thinking, oh, really? He did? That makes me wonder, like, where is that thinking of We the People? Like, where did some of that rhetoric go, or how in some of the records is he sort of struggling with that? Is there a tension between thinking about we the people and going to then being maybe a they the people that I serve in this role? Because to me that seems conceptually different in the way that we are thinking about what the government is and what that relationship is with the constituency. So that also, I think it's, I really appreciated the different sort of buckets that you also put forward, John. And one of the questions I also had, though, too, again, about the people, is sort of like in the buckets of government power and then executive and legislative powers that then go into it, like where does, like what about the 10th Amendment and the last few parts of the 10th Amendment and the people, like powers reserved to the states or the people? Like I feel like that also always gets sort of left aside, and so, you know, please tell me what that means. For Ethan, on for the Conceptual Foundations originalists, I think even if you sort of persuade me that this is the sort of most justifiable originalist space to be in, or most persuasive one, I wonder, do you feel like there's a catch-22 to it, though, where you're also in the place where it's also one of the more vulnerable ones to the like evolution of time and changing cultures and understandings? Because it strikes me that also like conceptions of like honor and duty and like how people understand the role of officers within a society or even law like would change dramatically in ways that would just equally change the actual force of these things and whether or not they are effective within the government structure. And so that would also be, you know, equally vulnerable to concern. And then the two thoughts from within my one of my other core fields, Indian law. So one comes from federal Indian law and the other tribal law, which are distinctive fields. So within tribal law, which is sort of the equivalent of like state law, if federal Indian law is like the federalism. So within tribal law, like it's really interesting to me because there have been periods of time in the history of the United States where the federal government has disestablished the existence of tribal governments, and so tribes had to explicitly pivot to a corporate form from being governments themselves and then go back. And so I think one area that would be interesting for folks who might be interested in looking into it to study further is the ways that you know, tribal governments or other governments are navigating what the difference between being a government and a corporation is like. And one of the insights that I've seen from that is questions of like efficiency that sometimes come out of being a corporation and the way that they have, after navigating a corporate status, prioritized things differently than they would in the ways they are prioritizing things as a government, and those shifts and how those are permeating. And then finally, so another thing that sort of just strikes me reading a lot of this literature is that you know, there is this very long tradition of the trust responsibility towards Indian tribes that has been part of federal Indian law for a long time, and it's been pretty much an empty, meaningless, largely unenforceable disaster, to put it kind of that directly and mildly. I think at best, I would say there was this hope that it would shape the federal government's behavior towards Indian tribes, and you know, like maybe it kind of has, but I think ultimately the story of the federal government's relationship with Indian tribes has probably not been controlled that much by this like rhetoric of obligation and promises as much as by other interests and power dynamics. And so instead, if anything, what this you know, trust responsibility has done has been these like two other really strange things, which has been to, within the courts particularly, take the behavior of the federal government, whether it's the executive or Congress, and within the courts sort of post hoc, rationalize it and say, well, we're going to apply this presumption that you were acting within good faith because we assume that this is your job and this is how you act. And so it kind of creates this strange gloss on actions after the fact, which I think can have a distortive effect, or certainly at least in Indian affairs has. And so I wonder if this is also a risk here as well, that this potential presumption of good faith can be ultimately distorting. Or, the other thing it sometimes does is allow for a limited construction of ambiguity in a certain direction, which is, I think, the only place it's really had meaning. So that's the other possibility. So those are my comments. You can answer them in direction.
Sure. Thank you, Liz. Those are terrific comments. I can't do them justice, but I'll try to respond to a few of them. I really like the observation and the question flowing from the idea of we the people. I refer to the fact that Wilson, among other things, was the person who drafted those three opening words of the preamble. But obviously I wasn't talking about that side of Wilson in my remarks today. It is the case that Wilson has long been viewed as the most democratic founder, or at least the most democratic delegate at the Constitutional Convention, and we could debate that, but what is meant by that is in part the fact that Wilson consistently took positions that to us are recognizably more democratic than most of the other delegates. So Wilson, in addition to proposing that there be a unitary executive, proposes popular election of the president. And the convention gasps and says that's a crazy idea. George Mason says that's like giving a trial of colors to a blind man because the people are too stupid and too incapable of making that choice. Wilson was much more democratic than people like Mason on that point. Wilson also was in favor of direct popular election of senators. So the 17th Amendment can be seen as catching up to Wilson many decades later. I think the deeper way to think about Wilson's views on democracy and all of this other work that he's doing to strengthen the national government really are going to turn on the theory of representation and how he and other founders understood political representation. Jack, Jonathan, there are people in the room who have written very helpfully on this question, and it's a deep and interesting topic, how the founders thought about political representation and then democracy in some sense, in our sense, although they didn't quite think in those terms. But I would say simply that this makes Wilson more interesting and I think more relevant for our times because he did hold these more democratic views on many issues. He didn't get everything he wanted, so for example, when the convention, when his trial balloon of direct popular election of the president went nowhere, he came back the next day with a proposal of the Electoral College, or something that resembled what eventually became the Electoral College. And he was a great compromiser at the convention. He was constantly willing to float ideas and then move to something that was more tractable and more of a compromise position. He did this on slavery, for example, many times with some terrible effects, obviously. So the 3/5 clause, for example. Let me just mention a couple other things that you, or respond to a couple other things that you raised. I guess the 10th Amendment is critically important. There's just sort of 2 points to flag here. There's a big debate in the first Congress and at the ratification conventions about whether the reserved powers clause should be broader by being formulated as powers not expressly delegated are reserved to the states or to the people, and that proposal is made in the first Congress. It's voted on 3 times, and it's voted down decisively. And I interpret that as an affirmation of the first Congress of wanting to keep implied powers in the government. There's a second point that's critically important that, frankly, historians have almost completely missed. and that is that Madison's first proposal of the reserved powers clause ran like this: powers not delegated by the Constitution are reserved to the states. And Madison specifically did not spell out that the powers to which he was referring were delegated to the United States. That was an amendment that was added by Roger Sherman in the House and Oliver Ellsworth in the Senate. And what I believe they were doing was expanding the reserved powers clause in such a way as to accommodate these implied national powers that I was referring to. The Virginia form of ratification actually didn't want this. In Virginia, when the Constitution was ratified, they ratified with a so-called form of ratification that, if you look closely at it, is really trying to say we object to the idea that there are powers vested in the government of the United States in addition to those vested in the departments and the officers. And this was a fight. Something was going on here. And at this point in time, Sherman and Ellsworth are far more nationalist than Madison. And a lot of this has to do with slavery. And then the last thing I'll say, with respect to federal Indian law and tribal law, I'm completely out of my competence in talking about tribal law. I think your work is so valuable on this topic, and I'm so glad that you are pursuing it. On federal Indian law, I'll just make one quick comment, which is there, as you know well, there's this case now that the court is taking up on the Indian Child Welfare Act. The debate, in part, turns on the scope of federal powers over Indian affairs, but also on other issues. And I'll just make one intervention here, which is, it is a consequence of the view that I am presenting today, that, for example, Justice Thomas's narrow construction of federal Indian power in the federal government, rooted in the Indian Commerce Clause only, or maybe that and the treaty power, that's the wrong way to think about it, I believe, if we're trying to be faithful to the original understanding. Because for someone like Wilson, that would have been one of these implied general powers covering all Indian affairs. There's an article coming out in Chicago, or maybe it's out now, called The Missing Indian Affairs Clause by a scholar named Lorraine Updike Toller. She traces the fact that in the drafting of the Constitution in the Committee of Detail, what had been a grant of power in the articles covering all Indian affairs, not just trade, drops out. She thinks that is either like an omission or some kind of, no, I think that's what her theory is. It was a kind of an omission. Wilson screwed up, and so did Randolph, and so did Rutledge, and they all just kind of missed the fact that they were not specifying this broader power over Indian affairs. I think that's a implausible reading of what was going on in the Committee of Detail. I think much more plausible is that among other powers that they didn't want to enumerate for political and strategic reasons was the broad power over all of Indian affairs. And so at the end of the day, the Constitution that's produced does, I believe, grant the federal government a broad power over all Indian affairs, not just commerce and the treaty power. And if that were true, then this issue in the Indian Child Welfare Act case would be an easy issue in favor of the government. I fear that it's not going to be an easy issue, because I think there's going to be a fight with this court over the scope of federal power in that case. So that's partly an answer to your question, but taking it in a slightly different direction.
I'll be briefer
Sorry.
than you, John.
Sorry.
I think all I want to do is kind of concede the point, and it's worth saying out loud. So when you go to fiduciary political theory conferences, every so often there'll be some whispers like, this isn't really a theory of democracy, is it? And no, it really isn't. So that's true. But it's a story about relationships, and I like the way you put it. It's a story about relationships that are particularly vulnerable to kinds of misappropriation and predation. And there is a good reason to think that officers of governments have access to legal and material resources of ours that they can misappropriate and leave us prone to predation. And it is essential that there be a story about power and accountability. So when you pivoted to talk about power and accountability, I think that's just what the fiduciary conceptualization is making more salient. But you are also right to say that it is also a theory of permissions and empowerment. It's not just a theory of duty. We have been emphasizing, in our Take Care Clause work, have been emphasizing the duty side of it because we think that there's warrant to think that the Take Care Clause, unlike the McConnell theory, is not a theory of empowerment, but it's there to do work to establish duties. But it is true that part of what gives the fiduciaries the very capacity to make us vulnerable to them is that it is so empowering. So that's very much part of the structure, not one we are always spotlighting, but it's essential to the entirety of the story, and you're quite right about that. I guess the only other thing I would say about this is that I think making it clearer and more salient what the role responsibilities are for those given offices and that hold offices in trust is more likely to produce better outcomes than what we have done, which is, so I like to think about it this way. If I tell my mother, that our officers they have a trust, they're fiduciaries, my mother would be like, I don't know what that is. And I feel like our job, in part, is to make it more understandable to the average citizen what it is that they are vulnerable to. And so when you use technical language like the language of fiduciary, it ends up working in this way as a source of oppression and domination. And it has been successfully used that way, and not only in the Indian context, but in other kind of contexts of colonialism. But it kind of works that way because we haven't done a good enough. We legal scholars, we legal historians, we legal philosophers haven't done a good enough job explaining what it means to inhabit those roles. So I take it that my project in part is to help forward the project of not using the discourse and rhetoric to engage in more and more oppression.
Great. Just two points. One is I think you're asking the most important question about all of this, because the challenge of fiduciary constitutionalism is that it needs to also fit into democracy. Here's one observation. It turns out that if I look back at McGirt versus Oklahoma and at the recent decision about the insular cases, I'm forgetting the name of it, one justice was the swing vote in McGirt, and what writes one of the most powerful opinions I've read in a long time, and that's Justice Gorsuch. And I don't think it's an accident that one of the most committed originalists was the most faithful to the history and the most concerned with the history, most concerned with the concept of trust with Native Americans and the betrayal of those groups, and as opposed to just voting with what was practical or easy. And I think one of the commitments of originalism is consistent with a faith. Elon Werman's, it's a debt against the living. We owe a debt to the past with law as text and context. So a faithful execution means that the executive branch has to follow the law in its text and context, as opposed to, and this is an anti-Chevron. I mean, the other thing I agree with Gorsuch on is that Chevron is bad law, and that Chevron should be overturned. Why? Because it's not about faithful execution of the law. It's not consistent with judging in Article 3. The job of judges and the executive branch is to get the law right, not just to look for what's permissible. This connects to Bijal's paper yesterday. I think it's right that it's both the job of the executive officers and the job of judges. It's the province and duty of the judges of the judiciary to say what the law is. If that's true of the executive branch and of judges, I also think it's true of not just statutes, but also the Constitution, and to get the law right in its text and context, in its original public meaning. The problem is, and this is where I think, Liz, you get to, I think, my anxiety about this project, is the gap between original public meaning as democracy, as Scalia's version of let's be true to the ratifiers, the public, as opposed to original methods, which I, with some degree of reluctance, I think John, Ethan, and I are all engaged with this question of, well, is it originalism if it turns on what the elites might have understood as opposed to what the public understood? And is this not potentially a fatal flaw of original methods? I'll bill you all for $300 for this therapy session later.
Well, this was absolutely terrific. I have so much to say, so I'm going to discipline myself and just ask John, well, so put a thought to John and ask what he thinks about it, and then ask a question to Jed. So I loved the paper, John, and I think that one of the things you're doing is, in a way, answering a question, or beginning the process of answering a question that Jed posed in the written version of his paper about the relationship between Wilson's defense of a very sweeping presidency and his claim that's recorded in all of the notes that the prerogatives of the British Crown are not the model, right? So how do you put these together, right? And I think one of the things that you're doing is showing that, in part, the answer to that question is that once you think of Wilson's view of the prerogatives that he was talking about as the prerogatives of the Crown that had been transferred to Congress, that these had become, from his point of view, national powers, which then had to be reallocated in their proper sort of dimensions, some being properly executive, some being properly legislative, and so on. And I think that's a really interesting thought. I wanted to put you another thought, because I think he means one other thing, which might be relevant. And that is that he knows that a lot of these, it's just the old point, that he knows that these are not, that these powers of the Crown are not actually powers of the King, and in practice. And that makes him a very interesting commentator. And I was thinking in particular of this disagreement that he has with Hamilton, where they're otherwise, very much allies on this side of things. Hamilton, when they're debating Article 1, Section 6, which prevents the executive from appointing to office, right, anyone who holds an office in the legislature, right? This is the thing that we were talking about, the great Bernard Bailyn, his vote for least, the sort of most underrated constitutional clause, since it's the one that prevents us from having a parliamentary system. But that, Hamilton objects, right, to that clause on the grounds, on the good, the sort of Humean grounds, that the influence of the executive is crucial in its ability to protect itself and its interests in the legislature. The kind of the old Humean argument, the executive must have this responsibility. And Wilson's response, very consistent with this picture, is, but that's only if you assume he doesn't have the veto anymore, right? Because the whole Humean point had been to say, this is a kind of second best, it's a kind of remedial power for that we make use of because the negative is now a fiction, right? Whereas Wilson's view is that once you actually restore the negative, you no longer need influence, and so you no longer need the power of places. So anyway, I just put you that thought because I think it's an interesting, and in a way it brings me to the question that I was going to ask Jed, because I had two thoughts about this. One is a kind of, particularly in relation to Wilson, is that the idea of associating a political constitution with a corporate charter, basically, in a way, it's a strange development because these are the people, including Wilson most spectacularly, who had spent the previous decade and a half resisting that argument in relation to the colonial charters. Right? I mean, this was the whole point. The ministry position was what you have are corporate charters, right, in private law, and in the position, the patriot position was absolutely not. These are sovereign bodies, and a sovereign political body is not a corporation, right, and not governed by private corporate law. So I just thought that was an interesting question. I don't know quite what to do with it, but it's just a puzzlement that I had. And then my question about the fascinating point about offices, because Ethan mentioned John Brewer, and I really wish he were sitting next to me because he would be able to, to whisper, reassurances, because I'm off the grid here. But my sense is that that here the situation is a little more complicated, because particularly in the British context, which is surely the one they're thinking of in relation to executive power and the question of appointment and removal, you have this interesting sort of heterogeneity, where some offices, so take the obvious one, like a living, right, like a benefice, is a living. That's considered basically fee simple property. And then you have middle cases, but by the time you get to things like the ministry, there's no question that a ministerial office is a piece of personal property. And there's no question that the king at pleasure can dismiss a minister. Now, that's a matter of law. In practice, of course, there were all kinds of constraints on the ability of the king to dismiss ministers. But it wasn't on the grounds that, but there was no sense that, that those holding offices of state held them via a property right. So anyway, I just put that to you. Yeah.
That's right, yeah.
Do you want to go first?
Sure. I think this is a very important tension that you've spotted between the patriot insistence that this is not simply, and part of it is actually part of the corporate form, and this is also something else that Elon, I'm encouraging Elon to write this up for this conference, is the recognition that corporations were a part of, to incorporate was a royal prerogative. And as Elon mentioned yesterday, it's pretty remarkable that when they had a debate over the Bank of the United States, no one said, Hamilton could have said, oh, well, this is implied because of the executive power and implied prerogatives. They didn't mention the corporation. So part of the tension here is that the fight in the early stage of the revolution around and then by the time you get to, I think what my intuition is, and in fact, I think I've got to read more Mikhail on this, is that the timeline, by the time they get to 1787 and they start, there's been 10 years of state constitution writing, but Connecticut keeps its colonial charter. Connecticut's the constitution state because they have the oldest constitution, which was their colonial charter. So at some point with the process of shifting from unwritten constitutions, but with colonial charters, I think that 10-year experience led them to change their minds because the revolution at that point was over, and it was not revolutionary at that stage, it was evolutionary. The point, in my paper, I acknowledge that I think the cabinet has a different role, but the cabinet ministers or that level of the secretaries of state and that high level privy council, we're talking about a dozen officials. And I still don't think you can get from that cabinet as royal practice or royal law and say that's automatically the president's. I think that's royalism. I know you're not suggesting that. I'm acknowledging that there was an English practice, but it was neither, but again, the power of removal was never mentioned in Blackstone as a prerogative, and it was never even mentioned as a power, because I think that it was understood that the cabinet was something different from the range of property for offices below.
Thanks for those comments, Eric. They're terrific comments, and I don't think I have a well worked out view on your point about Hamilton. I have to think about that. That's a really interesting question. Just a couple of points on the other issues. Yes, I think Wilson's statement that the prerogatives of the crown are not the right model for us, he believed that, and that helps explain what happened. However, I think he is foursquare behind the veto. Absolutely. He would like it to be a stronger veto vested in the president than the Constitution actually ultimately provides. He's also with Madison.
And of course, no advice and consent.
He is, that's right. So he's part of producing a draft by the Committee of Detail that vests the appointment power in the Senate, but he actually wants it to be vested in the president. And that comes out later in August. So Wilson is really interesting on this point. Part of what I would like to do, or I'm hoping I'm doing, is getting folks like Michael and Julian and Elon and the others who have really looked closely at the at the vesting clause and at the prerogatives and so forth, to think more about Wilson and this deep story about Wilson and what his jurisprudential and philosophical commitments were, because I think we can all learn more about the way the Committee of Detail drafted and built the presidency if we bring this into the mix. Yeah, let me just, I will say that I think Julian's work in particular, I think, blends very nicely to some of the things that I'm saying. So I'm probably more inclined towards Julian's view than Michael's view, I think, in the sense that the thin law execution interpretation of the vesting clause does seem to me to fit very much with what Wilson in fact says at the convention, and this point that I've tried to make, which is to say the royal residuum is real, it just goes to the national government, it doesn't go to the president. And that is the way Wilson, I think, fundamentally thinks about where all of these powers are vested by the Constitution. But of course, the necessary and proper clause authorizes Congress to carry those into execution by necessary and proper laws. So it is a real tilt in the direction of empowering Congress, but I think that's what he wanted. He was a Republican in that sense. He really did believe that the lawmaking function should be squarely in Congress's power.
Jed, I had some questions, but Eric got some of them. So I'll just stick with John. It's just an implications question. I guess my first question is, if I understand your argument correctly, you think that these government powers vested in the government of the United States, were vested in the collective of this union before the Constitution. So I guess my question is, what is it about the Constitution that vests these powers in them? Because that's what the necessary and proper clause says, vested by this Constitution. And so that just seems awkward if that's true. But let's suppose that it is true. Is the implication any different than the plenary powers doctrine? Are you just making a textual, because I've always been skeptical of the plenary power doctrine and the federal immigration power. Are you giving a textual basis for the plenary powers doctrine? Does it do any work beyond that?
Yeah, very briefly. Thanks, Elon. That's a great set of questions. Yeah, I think the second of the three necessary and proper clauses, which refers on its face to powers vested in the government of the United States, is in fact how one would supply a textual basis for all of those late 19th century doctrines, like plenary powers doctrine, the immigration power that's discussed in the Chinese exclusion cases, the way the legal tender cases are decided. There's an implied power in the government of the United States. In fact, in the legal tender cases, there's sort of citations back to Fisher, which in turn I think is very much reflecting a Wilsonian view. The federal eminent domain power that Will Bode wrote about in one of his early articles. All of these powers that I think are very plausibly vested in the government of the United States. I'm not a skeptic about that. I think that is how you understand it textually. Now, it does turn on recognizing that there's a class of powers that are implied powers. They're not enumerated powers. But that's exactly what Wilson believed in, and he said it over and over again. First of all, at the convention, he says, it's impossible to enumerate all the powers the government should have. He says that. It's a very important statement. That informed how he drafted the Constitution for the committee. And his bank essay in 1785 is really quite clear on this point. He thinks that despite the Articles of Confederation, which purported to limit the United States to expressly delegated powers, it still had a whole host of powers, implied powers, like the power to charter a bank. How do you get the power to charter a bank under the Articles of Confederation? Wilson says it's an easy question, because the states never had the power to begin with to delegate to the national government a power to charter a national bank. But that's one of those other acts and things that the Declaration vested in the United States. So he thinks the Articles was, an inadequate charter for the government of the United States, and he gets the second bite at the apple in 1787, and I think others are with him on this. I think Gouverneur Morris is right there with him on this. So the two principal framers, they were the Bank of North America's lawyers in the 1780s. They fought this battle over whether it was legitimate for Congress to charter the bank, and they're the two people who draft the Constitution principally. And I think Washington is completely with him, and I think Robert Morris is completely with him. I think the center of power and gravity at the convention was with Wilson. And that is why we have the Constitution that we have, and that's why they produce the Constitution that we do. But of course, our constitutional history has gone in a very different direction. So now it's odd to us to think that the government could have unenumerated powers, because we teach our students over and over again that there aren't no such things. But I just don't think that reflects the original understanding.
So my question is for Liz and for all of the panelists. I'm Katerina Linos, and my question is, what's the difference between a corporation? What are things that a government can do and a corporation cannot? What are the limits of a corporate charter? My work is in international law, and in international law, this is very much a live question. So when we think about how do we want to fight the next COVID, the monkeypox, we can say we want to set up an international organization, which is really similar to a government, like the WHO, or we want to set up something like the Global Fund, which is much more similar to a corporation. And some of the differences in international law have to do with immunities. So if you want the taxpayer money not to go to tort claimants, you set it up with immunity, but you can't set up corporations that way. A second difference in international has to do with efficiency, and Liz mentioned this. Somehow, if you set it up as a corporation, a lot gets done. Decisions by a small board get made quickly. This creates frustrated people who couldn't go through something more deliberative. And a third difference has to do with how others treat you. So if you're trying to interact with lots of other international organizations, they don't know what to do with you if you have this unusual form. So I'm just wondering, just historically, what did happen to tribes that had to be reestablished as corporations? What limits did they find, and perhaps some opportunities through the corporate form?
Yeah, so that's a great question, and the answer I think is fun and interesting, and because it's weird and super conceptual, right? Like, for the answer that I sort of feel like I have is that it sort of comes down to questions about under what body of law this entity is sort of incorporating in or like creating itself as at a very basic level, and that is sort of the pivot that's happening, right? Because corporations make rules for of governance internally, and so in some basic level, even when they're private, they're doing that. But when they make this pivot to being public, to being a government, that is different. They are making laws and often structure themselves very differently. So for those who are interested, there's a lot of interesting history about this. So in 1934, the Congress passed the Indian Reorganization Act, which authorized, which encouraged Indian tribes to adopt constitutions, largely, and also enabled them to have corporations as well. And so the provisions, Section 16 and Section 17 of the Indian Reorganization Act, which encourage both of those things, are right next to each other. Like one says, please, you can have a corporate form, which is actually your government, and then also you can incorporate a corporation under federal law, which you can use for various business transactions, land holdings, et cetera, which was actually quite important for tribes to be able to own land and property and different types of things, which they hadn't been able to do up until this point reliably in the United States. And in a protected manner. So this was a huge incentive for them. So a lot of tribes now have this government form and then a corporation which exists alongside them, sometimes with a relationship that's fleshed out in their constitution, sometimes not. And then sometimes when they have been in periods of disestablishment, either they went into the pre-existing corporation or the government became a corporation if one didn't exist, or back and forth. And it's super, super interesting and complicated. And tribal corporations have to navigate if they are going to incorporate under federal law, tribal law, state law, if they're going to have sub-corporations that do all those things. And I think it's a really interesting area to ask a lot of the questions that you're asking, and it provokes some of the things that are raised by this panel about what a corporation and the things that go along with its responsibilities really are at their essence, if anything, different than a government and decisions that we make about how to structure it. So.
Can I maybe just a brief point on this, because I think it goes to one of the critiques you sometimes hear about fiduciary constitutionalism. It's that it's kind of pulling from private law and just making this big category mistake, but it's precisely in the area of corporations. I mean, this is a presentist rereading of corporation as private law. I mean, that's of course how we all think of it today, but that's just not the way it was. So the corporation didn't have the status as a private thing in the way we think of it until, certainly not before the 19th century. And so, I think it's just critical to understand that the law of office there's a reciprocal relationship. I don't make it out as much in this paper, but a different paper I did with Andrew Kent, that the law of office is reciprocally interacting within corporate law and within public law, which we now would call public law, but then was much more continuous and informed one another. So some of the biggest cases of what we would now call fiduciary law that are happening in the 1700s in England are cases about corporations, and they talk about officers quite explicitly in the way we would now talk about officers of the government. There's a lot more to write about this and think about it, and it's perfectly relevant to much of John's work. But it is this, like, we just have a category mistake because of our presentist instincts about corporations as part of private law.
I want to make sure we get to Julian, but I do want to add to what Ethan is saying one other shout out, which was, when Ethan and I started working on this project, we were really focused on fiduciary constitutionalism as borrowing from private concepts. And Andrew did a deep dive into statutes, and what Andrew's insight was I don't know, I certainly didn't see it. Andrew recognized that the law of faithful execution came from statutes and public offices, and I think we have a modern, we have a dichotomy, as Ethan's saying, I think we have an overly formalistic dichotomy between public offices and private corporations, and these things were mixed in throughout English history.
Two questions. One actually for Liz and Ethan. I was really struck by the moment where you seemed to agree that the fiduciary frame, you didn't say is at odds. It seemed to me that you came close to saying that the fiduciary duty and democracy don't have much to do with each other, or needn't have much to do with each other. And I'd love to hear more about that, because I think one of the romantic attractions of fiduciary theory is that it moralizes the relationship of he or she who is put in place of representing they who have elected, right? It doesn't require that. You can have fiduciary theory, roles completely without an election. But I've always sort of liked the way that it takes the office and we talk about like faithful agency in legislative interpretation. The same kind of thing where there's a need to follow through on those what sent you there kind of thing. So I was curious to hear more about that. And then John, as you know, I've thought a lot in the stuff that I work on about what to make of silence and the dogs that don't bark and so on. And first of all, like your whole line of work excavating this is brilliant and convincing, and like you've totally sold me that Wilson thinks this way and that others do as well. One of the things I wonder is what we make of the fact that, at least so far as I've seen your research go to this point, we don't see a lot of invocation, certainly not in an unequivocal way, once the new machine gets up and running. And you do a wonderful job of showing how even McCullough, he's citing the full range of language, but of course much of McCullough really reads like, and you say this, really reads like the building on the congressional, the foregoing powers rather than, and so we'll probably come back to this non-delegation discussion, in an era where there was just like so much paint being thrown at the wall in every argument ever. How do we think about the fact that it may or may not have emerged? Is this a story about how best to understand the Constitution, or a story about like the intellectual lineage of the thing that came to be? Anyhow, that's what I was curious about.
Yeah, so on that point, so I think to elaborate a little bit more, I think the point that I was making about that is that it's precisely like you're saying, it is romantic, and that the romance can do deceptive work, I think. That if you had an unromantic notion of democracy and how it works, you end up thinking about democracy and accountability in a way that that doesn't need the romance of the faithfully executing to actually hold anyone accountable in any way, because democracy can do that. And so if the good faith is actually doing work that's in some way kind of either necessary or that's adding on top, then it can be kind of distracting or making us sort of believe in things working out in ways that might be pulling against some of our other intuitions on democracy, instead being the sort of pure agent that we look to hold people accountable. Instead, we want their conscience to do it or their sense of duty. And I think an instance of this that I think is really interesting, again from the work I do, is so the Cherokee Nation had this really abrupt constitutional crisis in the mid-late 1990s. And one of the things they did with their constitutional reform coming out of it was, do a lot of things clearly in response to, what got them there. And with a lot of the instances of sort of corruption and government failure that had come about, one thing that very much was put in was the people wanted the ability to directly remove people. So popular removal was absolutely put into the Constitution as a check. And so that's what I'm talking about. It's that's the kind of unromantic thing, version of a democratically accountable thing. It's the idea that the people could impeach someone from, they could impeach the president, that is, or principal chief. That's what Cherokee Nation decided to do instead.
I mean, so on the democracy point, one of the ways in which I like to conceptualize the sort of way fiduciary governance works is not as a full and comprehensive theory of government, but is almost like a plug-in for when you need to establish accountability. So I don't have a kind of romantic vision of this exactly. It strikes me as actually it can do important work. I don't think, maybe this is my idiosyncratic account of fiduciary law. There's plenty of discretion that's inherent in the role because you have expertise and you have access to other people's resources. So, and that's exactly why the duty is there, is to disable the fiduciary from being able to extract something from the beneficiary. But, to me, you think about arbitrary and capriciousness review, or think about rational basis review with bite. What the fiduciary conception does to help us understand the way those kinds of doctrines work is it tells the fiduciary, actually, we don't think you always have good faith, and when you bullshit us, we're going to invalidate what you do. Now, there's a huge range of deference that's going on, right? It's not like hard look review is always hard look. It's often soft glance, but what it's able to pick up on is kind of pretext analysis, and it's able to pick up on when what the agency is saying is just garbage. And so it gives courts mechanisms. And to me, that's fiduciary oversight. Right? Yeah. So similarly with rational basis review, there's a wide range of permissions we give to our rulers. However, when what they are proffering is clear bullshit, we say, you are not living up to your fiduciary responsibility. And that's a mechanism of, you betrayed us and your law doesn't stand. So I don't think of that as highly romantic. I understand that the rhetoric can be used in this way, but it is also plugged into larger sets of institutions that have, democratic features that may come from other commitments that we have, whether in the Constitution itself or more likely from state practices and state constitutions.
That's a great answer. Love that. That's great.
I'll just briefly respond to you, Julian, but very briefly. It's a great question. You know, what happened to all these ideas? Why aren't they more prevalent in the record? Sort of two cuts of an answer on that. The first cut reflects a symposium that Jonathan Gannap and David Schwartz and Richard Primus and I organized in the Fordham Law Review. Many people here contributed. And the basic premise of that was that a Federalist Constitution that was more or less dominant from the start through the 1790s gives way to a Jeffersonian, for lack of a better term, Constitution thereafter that dominates the first half of the 19th century. And many of these ideas go by the wayside, but not all at once. There are a lot of individual struggles. I mean, the battle over the Alien and Sedition Acts would be one clear example where a strong view of implied national powers has to give way to a new consensus. And then the second answer, I think, has everything to do with slavery. Because a government as powerful as the one I described would, in fact, have the implied power to abolish slavery. And that implication was quite clear to anti-federalists in the South. It's quite clear in the Virginia Ratifying Convention that this is a major issue. Patrick Henry and George Mason are saying to the Federalists, what gives? You know, this government has the implied power to abolish slavery, and the responses from Madison and Randolph are not adequate, I don't believe. This is a long story, but what happens in a nutshell is that the Quaker
And it
petition...
might be a short nutshell.
Oh, okay.
Because we're supposed to, we're yes.
So slavery is the
Yes.
one-word answer to the question, and over lunch we can talk about it some more. Thank you.
Yeah.
Great.
All right, thanks all.
Thanks.